All right, we're live. I put myself in the middle. You never know with you too. Hey, I don't want this to get bloody or crazy. How's it going?
Good. How you guys doing?
I'm doing great.
Doing well. I'm, relaxing. I'm trying to get over this, the scariness outside, but hopefully to take people's mind off of things.
Hey, did you see that tweet thread, Nate, that there's a lot of doctors who are coming forth saying, hey, wait a minute, they're saying the emergency rooms are filled up, ours are empty. Is this just a anecdotal thing, or is there possibly some exaggeration? Because they're claiming that their local press is saying that they're full, and they're saying, nah, we're really not full. What's going on?
Yeah, I don't know. I know here there's a difference between private hospitals and public hospitals, because obviously more people use the public hospitals because they have resources. So here the public hospitals, for instance, have stopped elective surgery, but if you go to one of the public hospitals, they're always packed versus a private hospital. So I don't know the particulars. Maybe they're right. Maybe there's maybe something to it. I'd have to see more about it, though. You know what I mean?
Okay, I dropped a link from a Twitter thread about it in the chat. So if anybody wants to go cruise around on that and chew, awesome.
All I know is that Ezra Levant of Rebel Media tweeted out yesterday. It's another one of these TikTok dance videos where nurses and doctors from hospitals are dancing, to a song. I forget what the song was. Lizzo. I get on it. And and everybody in the comment section is rightly saying, like, if you guys are overloaded, maybe this is not the right thing to do. And it causes people to ask questions that they would not otherwise ask.
I can see that, but then I also, I don't know. I guess I have gallows humor, but if you're under that kind of stress, maybe we should cut them a break. If they really are overworked and overburdened, it's like, okay, you know what? I'll give you an allowance to be silly if you're going to save my life.
Sing a TikTok song, right?
No, but it's. I guess it's the question of like a TikTok in the office versus a production of a TikTok that's edited, that has people outside dancing in the streets in coordinated dances. That there's one thing, and if things are that stressful, you probably are not in the mood to get 50 plus people doing a coordinated dance that takes time to coordinate. Mm-hmm. So it's the optics of it raise questions to people.
Yeah, I forgot what they call that, where everybody gathers up together. It's not photo bomb.
Flash dance or something like that, right?
Flash mob or flash dance.
Flash mob, yeah.
That's it. Perfect. Okay, so today.
Hold on a second, Eric.
Yes.
Nate. Sure. I finished Contra without losing a man. In
the
under
whole thing.
Minutes, the whole damn game. Now, the only thing is, after the heart blew up at the end, I got it. One of the alien things killed me, but I don't think it matters after the heart blows up. That's the game. I'm never playing the game again. I'm going to upload it to my other channel on YouTube because it's
15 minutes. The whole 15 minutes though.
It was 14 minutes and 10 seconds, beginning to end.
Wow.
Whoa.
A clean run. Oh, it was.
I've never finished the game without the 99 men. I always do the whole code, and I don't even go through it. I like to die as many times as I want to just have the freedom of dying.
It is not only the freedom to die. I made it every time. I once made it to the heart and then got shot at the heart.
Oh,
it's done. I can retire for a bit.
Contra. I love that game, man. I love that game so much. You don't know how many hours Contra has taken from my life.
It's beautiful. Now, but hold on. More important, Nate, do we start on our Twitter thread or do we start on the discussion of standing? I hate Twitter. I hate Twitter with a passion because you can't. The only thing it's good for is snark. It's not good for discussion, and you can see how it happens where you try to have a back and forth, and you're limited to, I don't know what the characters are, 140, and then something in between, responding to another tweet. I am prepared, Nate. We were having a debate on what is hearsay and what is not hearsay, and I think the entire discussion is somewhat a question of semantics. In that, if something is an exception to hearsay, is it hearsay but an exception, or is it not hearsay? And I think the outcome is ultimately the same. And I think ultimately we probably agree with each other. We're just getting at it through different ways.
Well, I was an assistant professor teaching evidence at the law school, and I also was doing bar prep. And it's one of those. There's a weird little quirk in American law between something that's an exemption for hearsay under Rule 801 in the Federal Rules of Evidence, and something that is non-hearsay or not considered hearsay under the federal rules. And it's weird because, to be fair, most states consider something like the party opponent admission to be an exception or exemption or exception to the hearsay rule. So in New York State, if you go in and say party opponent admission is not hearsay, they'll say you're crazy. No, it is hearsay, but it's an exception. As you were saying, that's fair. But in the federal rules, I don't know why they wrote it this way, and it's on every bar exam. So if you're taking the bar exam, you know this, and if you're going to take the UBE, you know this.
For federal, not for state.
No, the UBE for even a state, the state UBE, because it's all on federal law. So the UBE, when you take the questions, the question for hearsay is going to ask you, is a party opponent admission hearsay? And the correct answer to that question is it's not hearsay. That's because in the federal.
I would fight until I'm blue in the face, but at the end, there's two things. Mm-hmm. As far as our discussion goes, it's what I said. We're both right now. It just depends on the context. Mm-hmm. And then my next question to you would be, what constitutes a party admission? Because if a judge needs to determine if something is a party admission, then we're even more back in the original sense where someone's going to say, this is not hearsay because it's a party admission. The other party is going to say, it's not a party admission. Let's submit it to the judge. The judge is going to determine if the statement is a party admission that is not hearsay or an exception to hearsay. So it all comes to the same conclusion. And so I do think it's just semantics because it differs from state. Well, we're both right because it differs from state to state. And
No, I'm not saying you're wrong. It would be unfair for me to say that your objection is not correct because it is. In all 50 states, it's known as an exemption. But in the federal government, it's known as not to be hearsay. So you are correct. So we are both correct. And I want to be fair. You are
correct.
correct.
The weeds. One thing though.
Yes, we are. We are
up for the dummy in the middle.
All right. What happens is that
first off, what's hearsay? Let's start with just the basic premise of what's hearsay. I think everybody thinks they know what it is, but it'd be really awesome if you just flat out say this is what hearsay is, and this is why that's an exception.
Hearsay is an out of court statement offered for the truth of the matter asserted. So it's a statement that's said out of court and is being brought into court and is being offered for the truth of the matter. So an example would be if I say, Eric, if I'm on the stand and I say, and the question is asked to me, was it raining outside? If I say Eric told me it was raining outside, that would be hearsay. I would say because you made an out of court statement and I'm offering in court for the truth, the fact that it's raining outside. So that's what hearsay is. But for hearsay, there's something like 38 exceptions to the hearsay rule, things that can come out. Like say if somebody's dying declaration, if somebody's on their deathbed and says, Viva shot me and I die. that would be an exception to the hearsay rule. It would be a dying declaration. Now, in the federal rules.
Now, why is that an exception? Is it because you just can't, there's no way to talk to the person because they're dead?
Well, yes, and hearsay relies on reliability of the statement. Is it reliable that a person who's dying, who is telling the police this is the person who shot me? Is that statement more or less reliable? Is that person is more or less likely to be lying in that moment than in other moments? So that's why hearsay is really about whether the statement is reliable. I usually when I teach, I talk about the telephone game. How, every time someone else makes a statement, it gets muddled up. So that's what the law is trying to prevent. I think Viva's trying to get it. I'm sorry. Viva.
No. I would say, my understanding, it's not just reliability, but it's also testability, the fairness of being able to cross-examine on the statement. So deathbed confessions are the typical example just because they're so extreme and cut and dry. But a better example is someone says, they've died before trial, but they made certain not deathbed statements, but they've made certain statements. So they wrote on a piece of paper their testimony or, what they did on a certain day. So there, it's not a deathbed confession. It could be admissible just because you are no longer able to get the original person. But the reason why it's sort of unfair in general is because you don't get the original person. So
and the cross-examination, yeah.
And the cross-examination. And so so the funny thing is like with Nate, we're having this debate. If someone says the raining outside is a factual one, but Eric, let's not picky people. Mr. A says to Mr. B, I had an affair with my wife, and Mr. C hears it, goes into court and says A had an affair with his wife. I heard him say it to B. Well, there you would say there's the objection because you're saying you're trying to use that out of court statement to prove the fact, where every other lawyer is going to say, oh, I'm not trying to prove the fact. I just want to prove that C heard A tell B that he had an affair. And then that's how you try to get hearsay in as evidence or at least to affect the judge. But the whole argument we were having or the discussion was, I even forget the original example, but it went back to Vindman.
Right.
Testimony.
And the phone call with Trump and
so he in on the call. He heard Trump talking to Zelensky, and he relayed to Congress. Or was it the Congress? It was Congress. What he heard. He says, okay, I heard Trump and Zelensky talk about this, and this was my impression of it. Now, at the time, we all had the argument. This is hearsay, and people were, no, it's not hearsay. It's testimony. He heard this, and he's saying what he heard, but he was relaying what he heard out of court, out of Congress, as though to make evidence of what he heard. And then, we made the whole joke and then interpret it, and that's when you get into what's his face, not Schumer, the guy who said
some of this.
Who said?
Okay, if somebody's saying something. And they deny they say that, and a witness comes forward and says, "Yeah, no, they did say that." Is that hearsay or is that a witness? And
it all depends on where if they said it out of court, and now you have a witness because again, if you have a witness now who's impeaching, who's saying, well, this person said something, like it's now I'm forgetting my words. If you have a witness that is trying to counteract what someone else is saying on the stand, then yeah, you could bring that witness in and say, well, the witness says A, but I have this witness now who's going to say this person didn't say it, said B, and so forth. So the rules do allow for that, but you have to kind of open the door where one witness says I wasn't there, then you say, well, no, I have a witness now who's going to say no, they were there and they saw you there, or something like that. So you can bring in evidence that way. But the specific thing that we're talking about is party opponent admissions. It's like, let's say in criminal cases, it happens all the time, where the defendant themselves has made a statement outside of court. The defendant may say, "I'm going to kill you," right? To a witness or a complainant. They'll say, "I'm going to kill you," and now that complainant comes to testify and says, "Hey, when we were at the grocery store, the defendant said, I'm going, he was going to kill me," and then you have the objection hearsay. Now, in every state. Every one of the 50 states, that statement is allowed to come in because the defendant is a party opponent admission. So his statements are exempt from the hearsay rule. And in federal court, that can come in because the defendant's statements outside of court are not considered hearsay. So they can be brought in for the truth of the matter asserted. So that's the difference that we're talking about. In federal court, it's not considered hearsay, but in state court, they are considered hearsay, but they fall within the exception. Even
though under the federal court, it's in a section called exceptions to hearsay.
So I know, yes. And that's what makes it so confusing. But the rule, that's why I said the rule D says specifically, these statements that fall within this thing are not hearsay. And every student says, this is so confusing. But that's why on the bar exam, that's one of the first things they teach you in evidence. These statements, they're going to ask you, is this hearsay? And it's going to be, no, this is not hearsay under the federal rules.
And it wasn't Adam Schiff, it was Nadler who said, oftentimes hearsay is better than direct evidence. And that's what launched the entire war between legal who says, and it was never a question of whether or not hearsay can be admissible in the absence of direct testimony. The statement was, it's oftentimes better than direct testimony, which
is wrong, which is lie. Yeah, that's lies.
It's just nonsense.
Yeah.
And then, so
well, if they agree with you, right? No.
Say it again.
No, it is if they agree with you.
It is when you have no direct evidence.
What is it you always say, Viva, about lawyers? It's like if you have the evidence, you pound the evidence.
When you're strong on the law, you pound on the law. Strong on the facts, you pound on the facts. And when you're strong on neither, you pound on the table.
Pound the table.
There's another T-shirt. Pound the table.
Pound the table. Pound the table.
That is susceptible of being misunderstood. So. No. In fact, I was even thinking I was the other one that I was going to. Projection already is too long for a shirt, but no, that is a cancelable shirt right there.
I still say objection by whatever. Something by projection. Confession by projection is still great.
It's I might overuse it, I think, but it's when you see it, it's everywhere. But then again, I might be guilty of it when I see it everywhere.
That's why it's like a T-shirt, because you use it. It's like if you have words that you use a lot, it's like, okay, there's the T-shirt. Everybody's in on the joke.
Yeah, you know what? I might do it just so that every time, instead of replying it, I'll just take a picture, a selfie, and post that as my response.
Perfect.
So that thus ends the hearsay discussion. It really is absolutely academic, the distinction, because in some states it's one and federal it's the other, and at the end of the day it's the same procedure. It's like it's the same procedure to get in.
Well, it sounds like federal is looser with the standards than state. Is that a fair?
No, federal, just in federal court they just don't consider it to be hearsay. That's what it is. So it's not considered an exception. It's just considered not hearsay. But it's all bullshit, because even when you teach it, when you teach it, and even when you practice it, it's everybody calls it an exception. but just it's a technical matter, and that's what it is. In the federal law, it's a technical matter. That's the only distinction. And so Viva is correct. I want to make it very clear. Viva is correct when he says it's an exemption of the hearsay rule, because in every state and every jurisdiction, they're going to call it an exemption, except for the federal jurisdiction.
I'm doing the shirt today. We're doing it. I screenshot that.
You're gonna take the recording.
No,
No,
right.
but it's fair. You know, it's a correct analysis.
What was the original discussion? Oh, it didn't start with Vindman. It started with
well, the Supreme Court. There was so everybody. Yeah, so everybody understands the Supreme. There was a radio show who said there was an article written about someone who heard an anonymous person at the Supreme Court who heard through the walls that they were screaming and yelling and this.
Justice Roberts.
Yeah, so somebody was like, "Hey, Nate, do you think this is reliable?" And I was like, "Well," and you have one person saying they heard someone else tell them something that they heard through a wall, and they were able to hear who said what and what they were talking about and all that stuff. So I said, "Well, no, that's different. That's hearsay, but that's what I call third-party hearsay." Because you have the hearsay from what Justice Roberts said through the wall to the other person. Then from that person to now the person who told this other person who wrote the article, and now to me. So now you have now you have a longer chain within a hearsay, and the rules say you have to resolve each level of hearsay. So first you'd have to say, well, the Justice Roberts to the person who's listening outside the hallway, that could be let in because that's a party opponent admission if Justice Roberts was being, in court. And then you'd have to resolve the second part of the hearsay, which the person who heard it through the wall now tells somebody else. Well, now you would have to resolve that level of hearsay too. So that's the way usually the hearsay level works. So that's why I'm saying it just was less tenuous because you had more hoops to jump through to resolve the hearsay issue, rather than the Vindman thing, because Vindman was one level of hearsay, where this other one was a multi-leveled hearsay analysis.
And incidentally, that's what most people don't understand about hearsay is they think of hearsay in the colloquial sense where it's someone who heard someone else told him what someone else said, where in law, even if you are the one who heard it outside of court and you try to come in and try to prove it as a fact, that's still legally hearsay. And people sometimes have a difficulty appreciating that because they're saying it's testimony. I heard it myself. True. But if you're trying to relay it in court as a fact of the truthfulness of the event itself or the statement itself, that's hearsay. Bring in the witness who said it to prove true or false.
Correct.
What about weird cases like I don't know if this happened. I'm sure it's happened before, but a deposition is recorded, but only one side gets to do it and the person dies. Like they record on Friday for one side and then they die over the weekend. What's up with the deposition? Would that now be hearsay or is it not? Because nobody's allowed to cross.
But this now here is where you get into the weeds. Like you're really into the weeds because and let me know I'm saying that the federal laws have different laws. Like the federal law 801, it tells you, was the person under oath? Did the person give previous testimony? There's a procedure to let that in under the hearsay exception, and whether it's hearsay or not, versus in some state laws. Some state laws don't allow you to get it in. So now you're talking about each jurisdiction. But I think under federal law, if it all depends on whether the person was sworn in, whether the person had, whether there was a right to cross-examine, all these little nuances that that you'd have to dig into to see if that is appropriate in that jurisdiction.
Well, and also, Eric, typically the person is examining an adverse witness, so it would be at the very least party admissions because you're deposing the opposing party. If they die, all you have left is their statement, and it'll be able to be used against them. And typically, you can file it. It would be one thing if they died like mid deposition, if they hadn't finished the deposition, then what good is what you got out of them? But and it's also incidentally when you're dealing with elderly clients, why you get depositions and you do them back and forth, both parties to do it just in case. Because I have the last file I have has been going on. I think it was started in 2013 or maybe 2015 at best, and we were scheduled for trial. The lawyer died, scheduled for trial, pandemic. And, it's like, and they're elderly people who have literally died. Witnesses have died, lawyers have died. And that's it. But
I was thinking of the tobacco cases because, in the case of that or the 9/11 Victims Fund, where, you have people who have cancer, you have, very serious medical ailments that time does matter. Mm-hmm. Very, very, very much.
You depose them out of court. Each party gets to depose, and then you have their entire testimony anyhow. So both parties have gotten to examine and cross-examine. Is typically how you do it, just to preserve the rights. But you do it all the time when you're dealing with at-risk clients.
And plus, let's say somebody dies in a car crash too. There are protections in the law that allow their story and things to be told in a certain way that avoids the hearsay complications.
Okay, now I guess the most important question of all in this hearsay example is: did Justice Roberts say that, or are they full of shit?
It's got to be. Apparently, they're doing Zoom calls. So how? I mean, you would. In fact, the fact that they're doing Zoom calls, which is what people are saying to undermine it, doesn't necessarily undermine it. That might make it even more credible. Like where you'd have to scream in a Zoom call to make sure that your voice is heard on the other side. But it's the orgy of evidence. It's too perfect to fit the story, and I would be surprised if anybody at the Supreme Court level would behave like that.
Well, I'm even saying if it's true. Don't forget, you're talking about the top lawyers in the country who are clerks at the Supreme Court. There's never in the history of the 200 history of the Supreme Court have ever been a leak like this. Why? Because those people coming out of there are going into $250,000 bonus jobs and at the top law firms. And if it's found out that they're leaking stuff like this, it's going to be, it destroys their career. So, it would just, maybe they got some crazy but it just is. There's so much for that person to lose, to leak something that's so minuscule and minor. It just doesn't make any sense. But again, it's in relying on the source, I just think it's unreliable. I would need proof of life. Like I always tell my wife, I need proof of life for that.
I can't see him yelling at other justices, though. That's the part that doesn't make sense. Now,
especially
if he had a staffer called Neil or something, it'd be funny if he had a staffer with the same name as it, and he was yelling at a staffer, maybe. But are you going to tell me that Roberts is going to yell at Clarence Thomas?
No, but
come on.
What would be the tenor of that? Like, how would you get into that? It would be useless to yell in the first place. First of all, they all know it. It's not. It's like it's overtly stating what everybody they implicitly, explicitly, overtly know. If they were to hear that case and let alone hear it but overturn it, but I don't think hearing I don't think that's the reasonable conclusion that hearing it would have led to riots. And it's just too perfect to fit the narrative that people want to portray now. But I also think it's ultimately useless. It doesn't matter why they didn't hear it. They didn't hear it, and that's a problem, which we're going to get into right now.
Yep, we're segueing right into this, nudging it along here.
Nate, did you see Recchieta's rant the other day? It's
yes.
Rant I've ever seen.
Yeah, I saw it. I enjoyed it though. I think it's interesting because in looking at this issue, it's such a nuanced issue that I think it's easy to kind of just skip over what both sides are. And I think Robert and Nick's side are it's easier to understand, but I think when you break it down into the nuance, then just becomes clear. Like, okay, this is why they dismissed it. But again, we'll get into it in a second.
No, let's do it. So, if for anybody who doesn't know Nick Recchieta Law, and he's got a channel as well, and he put a 17-minute video where he expresses his discontent with the decision of the Supreme Court to not hear the case, not the judgment, to not hear it. And his reasoning, I think, is a little bit less to the right, but it's a little less extreme than Roberts, and it's definitely not slam dunk, totally understandable. And he makes some valid points. Most of which is, the most important of which is, this is a decision that affects 75 million people who feel a certain way. This is not how you dispose of that type of question of importance by ignoring it, so to speak.
Mm-hmm. Because I'll present the, I don't know, what would it be? The affirmative, Viva, that the Supreme Court should have heard it, that the states have standing, or that's essentially the side, correct?
Well, no, not even that they do have standing, but that if you're going to deny them standing, it's got to be motivated and explain why. Because, I mean, we'll get into it. In fact, Nate, you go and explain the standing issue, because
all right,
I'm not in the position. I'm more in the position, like, I can cross-examine and ask my question.
That'll be fair. Let me do this. Let me break it down. Let me see. I think I wrote something down. All right. So here's my argument.
Nate.
Oh yeah. So first, so this is what I'm talking about when I mean by standing. So I'm going to be taking the position that the Supreme Court rightfully dismissed the Texas lawsuit on the basis that Texas didn't have standing to bring the lawsuit. It's specifically that Texas didn't suffer a cognizable injury. Would you we agree with that, right? That's it, right? It's Texas didn't suffer a cognizable injury.
That's what they said in their 2-line decision. No standing, no cognizable. No, was it cognizable injury or cognizable claim?
Well, interest, but it's more or less. It seemed like they were saying that the Texas didn't suffer an injury. That's the reason why they were dismissing it. So that's what I kind of took away from it, because when we talk about standing, for those of you who don't know, standing has three elements. It's injury, causation, and redress. It essentially is the plaintiff has to at least allege that the defendant injured them and that the court can in some way give them appropriate redress. Can when they make a judgment, that'll be sufficient to give the plaintiff to make them whole again in some way, right? So that's what you're looking for. You're looking for an injury suffered by the plaintiff, the defendant caused it, and that the court can do something about it by giving them a good ruling. Either do an injunction or give you money or something like that. That's essentially what standing is. It's a three-step test. Now, one thing I do want to say about standing before we even get into the thing is that every famous case, there was standing. From Marbury v. Madison to whatever famous case, you will find that the Supreme Court decided on, you will find that they were standing, right? To dismiss the idea of standing is not serious, I think is naive in one way, is because there are few absolutes in law. Standing is one of those absolutes. It's not discretionary. Every court, every jurisdiction, every case has to deal with standing as a foundational issue. There is no case, no court in the United States that if a case is brought, standing is not a question that has to be resolved, because if you don't have standing, you don't go into any case. Now, I'm not sure if Viva agrees with that, but that is like my first principle. Standing is that foundational in court, that every court in the United States, every case in the United States, and every jurisdiction in the United States, every case has to have these three elements: injury, causation, and redress.
True. And just the most concrete examples. If you sue under someone else's contract and it's the best claim in the world, and you go into court and you say, I'm suing under this contract, and the court's going to say you're not a party to it, you have no standing, you have no legal interest in that contract, even if there's a bona fide good claim. The only thing is, that comes, I don't know what the process is in the States, but typically that's going to come as a preliminary exception. The terms may have changed now, but someone's going to file a suit. The court can raise it of its own volition, or the other party can say, his claim's beautiful, it's nice, everybody's great, except he's not a party to the contract. Or another example, which is another easy one. A contract is 20 years old and you only had 3 years to make the claim. You again have no standing. Now, sometimes though, standing can be more substantive in the way it's materialized than others, where it's a more nuanced question. Do you have standing? And so we're going to get into it on this case. This is not a case, although some people are going to say it's a case of Texas suing under a contract between Pennsylvania and its citizens. It isn't, in my mind. And if it were, it needed more motivation. And if it were not, it needed an explanation as to how they lack the standing above and beyond simply stating it. But I
have one question about standing that'll help clarify it in my head. And I think I'll have it right if I don't. Hulk Hogan famously took down Gawker because of Peter Thiel. Now, Peter Thiel hated Gawker with a passion and wanted to get Gawker, but he couldn't just sue Gawker on behalf of Hulk Hogan, correct? He needed to actually be behind the client. Is that because of standing?
Yeah, I mean, he financed the lawsuit, but he had no interest in pursuing it. I don't know what the rules are on selling claims in the States. So I don't know if Thiel could have purchased Hogan's claim. They have these people who actually sort of who deal
like
with
a debt collector. I can purchase your debt.
You can purchase.
Purchase debt. Yeah, but not claims though. In the United States.
I'm not sure if it works like that. But it's you can have people who purchase claims and then purchase debts and then institute claims on them, and they have it as a not subrogation, but rather they've acquired the rights to the claim. I don't know if that works in terms of like personal.
I don't know. It's here you have to kind of suffer the injury, but it's like say if you break your arm, I purchase your right to sue. I've not seen that. It's possible though. I have
to look into whether or not it is possible for personal claims like that. But no, Thiel, bottom line, had no interest in it. Could never have filed the suit or pursued the suit, setting aside some other that type of claim acquisition. But so he financed it. But no, but so that's standing. Like Thiel has no standing. Hulk Hogan does. Then the question, then its standing could be dismissed on another case like statute of limitations. But even then, you're getting into the substance of the basis of the claim. Where when Barnes, I saw someone say Barnes was exaggerating, but I saw another claim from another lawyer saying standing is a core concept of law, but it seems to have been institutionalized by the courts in the 1900s to basically be a short circuit to avoid taking cases they don't want. And we've seen it this election cycle around. where Pennsylvania says Trump has no standing in Pennsylvania because they haven't suffered an injury in fact. I don't know how they get to that determination without having been able, afforded the Trump campaign an opportunity to prove its injury. But in the same suit, they say the other plaintiffs who did in fact suffer an injury in fact lack standing for another reason, that they had to go to the county levels and not sue at the state level, something along those lines.
Well, to answer your first question, if you're doing analysis on standing, you assume generally the procedural position is that you assume all the plaintiffs' allegations are true. So if true, does the person still have standing? And if you haven't alleged enough, so they'll say, well, you haven't alleged enough here to allege an injury. That's when they say they don't have an injury in fact. It happens all the time. You haven't alleged an injury in fact, so you don't have standing. I'm not sure if that happened with the Trump campaign, but just generally how it is.
No, and so that's an interesting part, because that brings us into why the SCOTUS decision is even more of a problem. Is you take for granted the allegations, but I suspect it's the same as states. You don't have to take for granted the conclusions, because everybody in their lawsuit says, I'm right, therefore give me money. But if you had to take that conclusion as granted in the context of a motion to dismiss, no lawsuit would ever get dismissed on standing because it says I have standing. In Texas,
hold on. Say that one more time.
Well, you don't take the conclusions of law for granted in the context of dismissal for reasons of standing, for example, or a motion to dismiss. Because if you take conclusions of law for granted, you'll never get the lawsuit dismissed on a preliminary motion, because if you take it for granted, the lawsuit's going to allege the conclusions are justified. So you take for granted the allegations, but not conclusions of law.
Yes, correct. That's correct. Yes.
With Texas, their allegation was that our vote is being diluted through the allegedly unconstitutional conduct of the defendant states. Now, that's where I say, that's not so much as a conclusion as it is an allegation. And if you take that for granted, I don't know how you then go and summarily dismiss standing. And this is where Nate's going to say, I think, that it's so obvious they lack standing that it doesn't, merit more of a fleshing out.
Well,
but
I do. Right? Well, that was the weird one. Is it mattered because the vice president would be president of the Senate, so they're losing their Senate standing or something?
I think that's what they were. I think that's what they were trying to allege. But here is what, and again, the Supreme Court didn't exactly say why they didn't, they just kind of gave this, there's no cognizable interest or whatever, and that seems to be. But here is my understanding of the logic and why I think most of the people who kind of saw this coming, what we understood it to be, and it takes a little bit more flushing out than just to say there was no cognizable interest. For instance, Texas specifically said that the part of the Constitution that was violated was Article 2, Section 1, Clause 2, the Electives Clause. And the relevant section reads, each state shall appoint in such a manner that the legislature thereof may direct a number of electors, right? So that's where they were saying, well, this piece of the Constitution, this piece of the contract between states was violated because the legislature essentially passed laws and the executive and the courts violated those laws in picking the wrong electors. And that violation of the legislature's laws, what the legislature said, is also a violation of this article, this section of the Constitution. Therefore, that gives us the ability to sue. Is that correct?
That sounds about right as far as my understanding was. I mean, I'm sort of not. I don't think I'm oversimplifying it, but they basically said, they followed unconstitutional laws which violated the Electors Clause.
And then it violated with the legislature in the state. They violated the state law, and since they violated the state law, that violated the Elections Clause, the Electors Clause.
So Nate, does that mean then that if you're a citizen of Pennsylvania, from your argument that a citizen of Pennsylvania could sue the state saying that you violated the state law? Yes. And as a citizen, you're violating me. I'm injured, and they would have standing versus Texas being an outside state. Is that your argument?
A citizen can sue. Well, number one, a citizen can sue the state in state court saying, "Hey, it happens all the time. You violated this state law, and we want you to stop or whatever." Or the citizen that state can sue and say the state violated federal law. But another state can't say this state violated its own state law. Generally, that's the thing. So Texas can't go in and say Pennsylvania's drinking law is unconstitutional, right? Because they don't have the authority to do that. They don't have the
But you see,
standing to do that.
that's where I have the problem, Nate, with the
Mhm.
reasoning that this was not a state law that only impacted the state. The whole argument was that this was a state law that impacted the members to the Constitution.
All right,
And
so now let me explain why, and that's why I said. So give me like 2 or 3 minutes, because this is where the nuance gets in. I think this is where the understanding breaks down. All right, so if we're talking about the Electives Clause, this means, right, the Electives Clause, this means that the state legislature has the authority to make whatever rules it wants to for the electors, right? If now, for most people who are listening to us probably don't understand, is that when the Constitution, at our first couple of presidential elections, the state legislatures picked the electors. They didn't pass the laws. They didn't do that. They literally had votes and said, we're going to pick these legislative electors. So that's what they did. They picked electors. New York, Massachusetts, there was no popular vote. Some states had versions of popular vote, but most states legislatures said, hey, we're just going to pass it ourselves, right? We're going to do it through resolutions. We don't want to get anybody else involved. And as over time, states changed that. So at that first point, at that first constitutional convention, when the state of New York chose X amount of electors, Texas right now couldn't go in and say, well, New York, you know what? We don't like the electors you picked, or we don't like the way you picked your electors, right? Because it doesn't work for us. So we're going to sue based on you violating the Electives Clause. At that point, I would say Texas wouldn't have standing to sue, right? Because they don't have the ability or the authority under the contract to tell New York State's legislature how to pick its electors. We would all agree with that, right?
Well, back then they picked the senators too, if I recall.
Yeah. But Texas wouldn't be injured, right? Because the Electives Clause says the legislature can pick them whatever they want. The legislature picks them themselves. So Texas wouldn't have any injury, right? They would say, well, you don't have any injury. You can pick yours the way you want. New York can pick theirs the way they want. So what? So, and now, fast forward a couple of 100 years later, New York then says, okay, well, instead of us picking our electors the way we want to pick them, instead of just picking them, we're going to let it go to a popular vote. So we're going to pass laws and a state constitution. And within that laws and state constitution, we are now going to allow our citizens to pick the electors. Now, even at this point now, let's say Texas says, well, listen, we don't like the fact that you're going to now let people vote on electors. So it's the legislature, and you are, by letting people vote on electors, violate this part of the Constitution, right? We don't like the fact that you're letting other people pick the electors. Well, again, Texas would not have a cognizable injury, because even though the state legislature of New York says we're going to let the people vote, they get to choose the manner in which they vote, right? Because that's what the Constitution says. So Texas hasn't been injured. Texas can do whatever they want. New York can do whichever way they want. So again, Texas would not have standing to sue in that situation.
So you're saying that, so I'm interpreting correctly. You're saying essentially every state has X electoral votes.
Yes.
Give me your votes. I don't care how you get them.
Yes, but the legislature,
nothing else. You can make up your votes. Your people can vote whatever you want to do. You have X number of votes, except
if they violate something like the Equal Protection Clause, where if you say no black people can vote, right? Because that would be a violation of another constitutional provision. You're now, or if it's a poll tax. If it's a poll tax, that violates a constitutional provision.
But if another state accused them of that, would there be a standing? That's their internal problem. And I wanted to go there because by your same argument, I would say, hey, it's a racist state. And I don't believe in that. I'm in Virginia and you're South Carolina. We'll pick somebody, whatever. And you're playing games with poll taxes and gerrymandering and redistricting and whatever, and you're not legitimately going forward. Well, that's not my problem. You're Virginia. Worry about Virginia. Don't worry about my state. So it's kind of hard to have it both ways, isn't it?
Well, no, I think you're misunderstanding. In one instance, it's saying the state can choose what electors any way it wants, right? Unless it violates the Constitution. So the constitutional provision we're talking about is, yes, the states can choose whichever way they want, unless it violates one of these other provisions, for instance, racism, right? So let's say
the state legislatures had to pick it. So wasn't it by default violating the Constitution?
But how's it? All right. So if the state legislatures get to choose the manner in which it picks it, and the state legislature says, we're going to let people vote for that's the manner we choose. How does that violate the Constitution?
Well, but Nate, hold on. That's missing.
Hold on. No, but I'm asking.
From what I understood, and this is where I get confused. the state legislature did not approve the laws that were put in place that were allowing the mail-in voting and things like that. That these were put forth by the Secretary of State and the governor of the state, but the state legislature actually did not make the decision. So the argument is that no, you violated the Constitution because it wasn't your job to make that; it was the state legislature. So that's all I'm saying. And again, I don't know this stuff. That's just where I kind of feel.
And it's not that my understanding is that it's not that the legislators enacted rules that Texas is challenging. It's that the legislature under the Electives Clause is supposed to enact the rules. That's what the Constitution says. But locals went ahead and made changes that the legislator did not approve, which therefore violated the Electives Clause of the Constitution. And it had an impact on Texas in that it basically dilutes Texas's vote, who followed the Electives Clause and followed the legislature, whereas Pennsylvania, Michigan, Wisconsin, and Georgia did not. That I think is the crux.
All right, but hold on. But see, and that's why I'm saying, as we go down, right? At first, when I asked you guys initially, I said, and this is why I'm trying to bring it, because again, it's nuanced.
Sure.
When I asked you guys initially, if Texas told New York, the New York legislature, they said, we're going, you know what? The manner in which we're going to choose electors, we're going to have a dog race, and whatever dog wins, if the white dog wins, goes to the Democrats. The black dog wins, it goes to Republicans. Right? It's just that's the way we're going to do it. Does Texas have standing to tell New York no, they can't do that?
If that's what the legislature,
if that's what the legislature says, yes.
I guess not. I'll go ahead and say they do not have the right to interfere with state law as relates to their exercising of their authority under the Electives Clause.
Good. So now so what did the states actually do? These states now passed laws, right? They said, we're going to pass laws, law A, and we're going to pass a state constitution. Now, those laws, whatever manner those laws are, we're passing those laws. And now, since we passed those laws, that's the way we want to, in the manner in which our elections. So now after they've passed laws and said the state constitution, this is the way we want to do it. Can Texas now come and say, we disagree with those laws, we disagree with that constitution? You can't pass it in that manner. I'm just asking that's a very simple question. The legislature passed
if the legislature did, sure. If the legislature didn't,
hold on. I'm just there. If the legislature passed it, because we agree, they passed the laws, they passed the Constitution. That's a true statement. So if they did that, does Texas have the ability to sue? That's all I'm asking.
The same example.
In that case,
no.
Okay. So now this is what happens. So now when the state legislature passes the laws and passes a constitution to say this is the way we want our elections to be run, that invokes two other things now. That invokes the executive to now execute the laws, right? And that invokes the judiciary to now interpret the laws. Because when the state legislature passes a law, they now delegate that authority, because now they had the whole authority to say we want whoever we want. But now they said we're going to delegate and pass a law. Now, the person who executes that law is the executive of that state, and the person who interprets the law through those are the legislature. So now, even at this point, because now they've delegated that authority to the executive and to the legislature, Texas now couldn't say, well, we don't want you to delegate that, right? They would still not have standing, right?
Because I'm not legislature doing it.
No, I'm just going right down the line, step by step. So I'm asking that, and that's why I'm taking it step by step. We're getting there. You guys want to jump to the end, but we're taking it step by step. So at that point,
step is saying if the state legislature,
yes, and I'm going to keep saying that.
The first step, what path are we traveling?
I am still going. I'm still going down that step. That's why I keep saying if the state legislature passes a law, which they did. If the state legislature delegates to the executive, which they did, they've done that.
It's heated agreement.
There's a principle.
Okay. So we did a disagreement. Go ahead.
Potest non potest delegatur, delegatum non potest delegare. That they're not necessarily allowed to delegate legislative authority to the executive. So I'll stop you there.
What? Huh?
The legislative cannot delegate legislative authority to the executive branch.
I didn't say that. What they did was say the manner in which electors are chosen. They pass laws that delegates the authority, right? Because, for instance, when they pass a law and say we want, just so you guys understand how, well, maybe you may not understand how it works in the U.S., but when the legislature passes a law, they don't execute the laws, right? The person who works for the poll place works for the executive.
Go ahead. Executing the law is different than delegating. So the legislative, we agree, passes the law, the executive enforces the law, and the judicial interprets the law. We all agree on that.
No. So all right. So
but let's skip it. Well, we can skip a step.
No. You because the thing is that we all are not agreeing at one thing. When a state passes a law, what happens?
The executive enforces it. The judicial interprets it.
Exactly.
When the executive modifies a law without going through the legislative,
I haven't gotten it yet.
As they're doing elsewhere through executive orders, that's when it becomes an unconstitutional law, and then it becomes a question of not the legislative carrying out its duties and the executive enforcing them. It becomes the executive carrying out the legislative duties to the detriment of Texas, in theory.
All right, but now that's the reason why I'm going slow, because you jumped to the conclusion. But I'm just going step by step to show when the legislature passes a law,
they pass a law,
and so then when they pass a law. So when they pass a law, we're going to allow the elections to happen this way. So the executive now goes and hires staff and has polling places to execute that law. And then there's going to be so that's their job, right? The polling people work for the executive. And then if there's a problem with what does this law mean? It's the legislature who interprets that law, right? Now at this point, Texas. Now the judiciary interprets the law, right. The judges. So even at this point, we have a law passed. We have them doing the polls and hiring the people, and we have the court saying, all right, this is what the law means in that state. Texas, at this point, doesn't have authority to now say that the state can't do that. They don't have the authority to say the executive can't hire poll people. They don't have the authority to say that the judiciary can't interpret that law, right? We agree with that, right?
We agree that Texas has no business telling Pennsylvania how the executive should carry out the laws that were passed by the legislature. We agree with that. Right. What will be the next step?
So now the next step is that now the argument when we get to the next step, which is here in all these states, the argument is that the legislature passed the law and the executive,
but they didn't.
No, wait.
No. What do you mean by they didn't?
The legislative passed a law. It says that
no. You keep saying they didn't. What law didn't they pass? Because they all have election laws. So
okay, well, they had election laws, not the ones that were enforced. They came in after the fact. So what was actually enacted was not what they passed.
All right. So are you who determines how to interpret that? Are you the best to interpret that, or is it the state judiciary best to interpret that?
Okay. So the question is now. The answer is typically state courts will interpret state law. Okay. But the other answer is Supreme Court can interpret state law and does. So this is time constraint, importance, skipping the state law interpretation, asking for permission to go straight to SCOTUS, which is what they did. But you didn't get to the end of your analogy yet.
So I'm trying to get there. So right now we have states that pass. Now in Georgia, they passed a state law. They went through the election. Now Texas's argument is simple. Texas' argument is that the executive didn't execute the laws right. Matter of fact, they said they violated what the legislator wanted. And then they said, well, the judiciary, they interpreted the law, right? They made it all up, right? So that's what you guys are saying. They made it up. They interpreted the law wrong, and they almost made up their own law.
Well, I hate to be a pain to throw it in there because this goes back to your constitutional argument from earlier. But, in the South, the judiciary surely held up Jim Crow laws.
Okay, yeah.
Forget the analogy.
And the Supreme Court ultimately came down and said, "Hell no."
So, but that violated the federal constitution. That violated the federal constitution. And that's what I'm saying. I think. But that's what I'm saying. There's a difference in the way, and we were talking about. And if you just, it's like that. That's what I'm trying to break. That's why I'm being very specific in saying, here's the analogy. Violating the Equal Protection Clause is different than trying to say the state legislature can't do this. So that's why. But let me just make sure let me just get to the end of this point. So now I'm accepting everything that you guys are saying is true. The executive violated the law, right? And the judiciary violated the law. They made it all up.
Stop. I'm not saying the executive violated the law.
Okay, go ahead.
I'm saying the executive purported to create the law.
I'm agreeing with that.
Okay.
Executive created new law, judiciary created. I'm agreeing with all of that.
Okay.
Right. But then there's still state certification after that, right? So after the election happens and you have a result, the states then get to certify the election, right? The state legislature. You go to the state legislature. Remember, Rudy Giuliani went to Pennsylvania and said, hey, all these things happened wrong at the election. And the legislator at that point, because as a stopgap, all the legislators can say, well, you know what? They got it wrong. The executive messed up and the judiciary messed up, and we're going to choose our own electors. So they heard the evidence from Rudy Giuliani, and they said, well, you know what? We don't think they got it wrong. we're going to send these electors. Same thing in Arizona. Arizona, right? Julie Giuliani went to the Arizona and said, hey, they got it wrong. Arizona heard them and said, hell, you know what? We don't believe they got it wrong. These are electors we're going to send. So even if everything you're saying happened, everything was wrong, the electors, by certifying the result. Okay,
that's where you're going. If the electors accepted it, and if they had shut their mouth, then when
the legislators accepted the result, now Texas is saying, well, all these other people violated the law. But at that point, it doesn't matter. That's why they don't have standing, because the legislators themselves certified the results. And if the results were wrong, they had an opportunity before certification to change those results, and they chose not to.
Question though, how is that standing versus a decision? Because that sounds like what they should argue out in the Supreme Court and say, here is why we're not going to give you, what is it called, redress or whatever, because you screwed up, you're too late, boom, case out.
Well, Eric,
they could listen to it.
Let me just make one point, because that's we're getting there now. And Nate, it's not because you didn't explain it properly. It's that even if 7 of the 9 justices agree with you, that is the reasoning that they had to say out there so that people could at least follow the reasoning. Second thing,
hold on. Is my reasoning wrong though? That's what I'm asking. Is my reasoning wrong?
No, bring that chat back up. I disagree with your reasoning, Nate, because you've admitted of at least one exception where what a state does could be challenged by another state. And so the only question is this another exception? And you're not going to tell me that when it comes to unconstitutional laws for violating racism or any more cut and dry examples. Mm-hmm. Well, sure, there Texas can have standing, but here they don't. You've admitted.
Okay, I'll explain to you.
Sorry,
I'll explain it to you because don't forget, every suit is different and every claim is different. And in this particular suit, Texas is saying that the will of the legislature was violated, right? Because the state executive made up their own law. Eric was saying they made up their own law. They did their own thing, right? But then no one has said that the state legislatures were the ones who then certified those results and said, this is the way, these are the electors we want. Now, since those state legislatures did that, since they certified, hold on, Viva, hold on. Since they certified, now we go back to the Constitution. And what does the Constitution say? By the manner in which the legislature chooses to pick their electors. Rudy Giuliani went to all these legislators. They said, okay, this was the manner. At the end of the day, these are our electors. So now that is why Texas doesn't have standing, because Texas is saying, well, they chose the wrong electors. But at the end of the day, they didn't. You know why? Because it's the legislators themselves who had a chance to say this was wrong and we want new electors, but they didn't. They certified it. And that's where I think Barnes's argument fails, is because if the legislatures didn't certify the election, then you would have an argument. Okay, they violated this and maybe the Supreme Court should look at it. But because the legislature certified the Safe Harbor Day, we know about what happened. That is not, now you can't say, well, we don't like the electors, because your argument is now moot because the legislators themselves certified the result.
Well, I mean, what you're saying is tantamount to saying there's an election clause. So long as they certify it,
not the legislature. So I don't know if this is true or not, but if that is the case, what if it is the Secretary of State that certified it and not the legislature?
Who gives the authority to the state Secretary of State to certify the election? Well, under what authority?
No, I mean, that's part of their job, right? They have to vote? I don't know the process.
The authority must be given to them by law, right? There's a law that was passed, and who passes that law? And who says these are the final person who tells us
just the electorate? It
is the state legislature.
That seems kind of weird.
Can the state legislature give me the power? Can the state legislature not hold elections?
Yes, if they choose to. Yes.
Can the state legislature hold elections? And I'm just going back. I don't want to go back to the bad analogy. The state legislature has to certify the electors. Now you're saying that the state legislature can, what's the word that we just used? Can delegate that authority to somebody else. So the state legislature can pick someone to pick the electors, or can pick someone to certify the electors.
They can do it in a manner in which they choose. They can the manner, right? They can do it. Remember, we made that give the analogy of a dog race. They can do it. They choose the manner in which they pick their electors. It doesn't tell them they have to do it a certain way. They don't have to have a vote. Remember earlier on in the Constitution, they didn't have the votes.
This is really confusing to me, and I admit I'm dumb. But you're saying that the state legislature certified it, even though they didn't have a vote and say, yeah, check, stamp. you're saying that because they said, yeah, that's the Secretary of State and they have authority, that is a tacit certification, because then the Secretary of State said, well, I'm going to go certify it. You're saying that the state legislature
hold on.
go run and put a roadblock up and say, whoa, wait, stop. We changed our mind. I don't understand.
Just to be clear, the reason why Rudy Giuliani went to Pennsylvania was because the state legislature could have said, right? They could have said, well, listen, the election was wrong. It was bogus. And we're going to certify a totally different slate of electors, right? These electors are no good. They had that right. That's why Rudy Giuliani went and testified and brought witnesses, right? This is what happened. And after he presented his arguments and said this was all wrong, the state legislature said, nothing to see here. We're gonna let this certification go through.
They did nothing. You're saying they did not. Hold on. You're saying they did nothing, right?
Some state legislatures vote to certify. Right. Some that have delegates. Some have said, well, you know what? We're going to let the states, what's it called? The state Secretary of State certify the election, right? In other words, instead of us doing it, we give the power to the state Secretary of State. They can do it. But now, in either case, if they do it themselves or if they give the power to the state Secretary of State, that's them, right? Saying, yes, this is what we want. And at any point in time, they could have said, no, we don't. We want our own electors. And since they didn't do that, Texas has no standing to sue because the state legislature, that's the reason why Rudy Giuliani was going. The state legislature has tacitly said and has passed laws and said that this is the way we want it done. This is the way it's going to be done. And these are the electors that we chose.
Nate, could the state legislature have certified the results of an illegal vote, an unconstitutional vote?
No.
Okay. So there are situations in which the state legislature certifying it is not going to be done deal.
But they didn't. He's saying they're certifying by abdication.
No.
They passed the law. They passed the law. They certify.
They certify the electors. Can the state? Can the legislature certify the electors of a vote that is an unconstitutional vote?
Is that what happened here? Is that what's being alleged? Was there an unconstitutional vote here? Because I don't. The only reason why I'm asking you that,
Nate, is there any circumstance under which the legislature will be forbidden or where their certification will be annulled for reasons of unconstitutionality?
Will it be annulled for? No, I don't think it will. What happens is that what happened in like 1770, I think it's 1872 or 1876. It was Grant's election. There were some widespread voter fraud and some constitutional issues. So the Senate, when the state of Georgia and I think Louisiana certified their electors, and when went to Congress rejected those electors because of those reasons. Because again, the states had the right to certify the election whichever way manner they wanted. But when it went to Congress is that final check on January 6th. And they said, well, listen, because of these voting irregularities, we are not going to allow this state's electors to be counted in the overall tally. So they can certify illegal or, if you want to say, unconstitutional electors. But then the stopgap will be at Congress. Congress will say, well, we reject those electors.
That's good. So there are circumstances in which the legislature certifying electors can be undone, so to speak, or can be invalid because they've certified based on a racist vote that excluded certain members of a race from voting.
But that's not the Supreme Court though that does that. That would be at Congress if they did do that.
Oh well, arguably, I'm not sure that it would. I don't know. I would imagine if the legislature certified electors that was based on a vote that violated equal rights.
The federal Constitution.
Yes. Let's just say go federal Constitution.
Any part of the federal, but that's not what's being alleged here.
Well,
hold on. Just let me be clear. You're arguing that they violated the federal Constitution.
I'm not arguing
Texas, but
I'm asking you a question. Are there any circumstances under which the legislature certifying electors can be invalidated by the Supreme Court?
Yes, and there's two things I want to make it very clear. We're arguing. Your analogy is based on the federal Constitution, them violating the violation of the federal Constitution. Texas's argument is their violation of state law in the state.
No, it isn't.
Just let me finish. In Texas's own pleading, Texas says that they violated state law, right? State law is being violated. And in Viva's analogies, Viva said, well, hey, these, black people not being able to vote, that violates the federal Constitution. So Tell me just specific, because you guys keep saying this violates the federal constitution. Let's be specific.
Electors Clause.
What article? The Electors Clause. Which piece of the Electors Clause?
Well, I'll pull it up. The one that says the one that says that the state determines it based on the legislature creating the rules for the vote.
And did the legislature create the rules for the vote?
They did, but they weren't followed. Okay. So then
the vote was carried out.
Okay.
The whole point is that the state violated the Electors Clause because they did not follow the rules that were implemented by the legislature in accordance with the Electors Clause of the Constitution. And
right,
so that if that is not redressable, like Barnes has said, then you have a provision of the Constitution that is a right with no remedy. And then in which case, take that provision out. Just don't make the legislature that clause doesn't exist.
No. See, the thing is, you can't have it both ways. The legislature passed the laws and said, this is the way we want it done. It was done that way. And then at the end, the legislature, hold on, let me finish. The legislature passed the law. The legislature says it was done the way we wanted. The Supreme Courts in those states said it was done the way we wanted. The executive is saying we were done with the way we wanted. Texas is saying, well, you know what? We believe that you're wrong. We believe that it wasn't done the way even though the legislator at the end of the day had a chance to say, we don't want these electors, throw them out. Did they say that? They say no. So now what you guys are saying, hold on. Let me make it very clear. What you guys are simply saying is that the legislature's wrong because they said these are the electors we want. The executive is wrong because they made up their own law, and the courts were wrong because they made up their own law. You're saying that those states, all those people, all those legislators who then certified the election after all this happened, who said these are the electors we want, are all wrong. That is why Texas just doesn't have standing. I'm sorry. I'm
not saying they're wrong. First of all, I'm not saying they're wrong. I'm saying that
Texas is.
I will say that it is a undisputable fact that the protocol that they implemented as far as the election went violated the legislature and the law as drafted. I think that's a undisputable fact.
No, I don't think that's undisputable.
Then we at the very least we have a disagreement on fact. But when they said,
I'm thinking that is true.
When they said indefinite confinement can include people who is everybody basically because of COVID, where the law says no, it's not everybody, it's specific requirements, and they included everybody 200,000 votes under indefinite confinement where it should have only been a quarter of that. That is. I'm not saying that that's not true. I'm taking that as fact, right? I'm taking Texas's argument as fact. Whatever you say, I'm taking it as fact. Okay,
I still don't think. How do you get over the fact? Hold on. How do you get over the fact that if you're saying the legislator has the ability to pick the electors, and at the end of the day, when certification comes in, and when Rudy Giuliani went in front of all those state legislatures and said, "This is what happened," they brought up all these other things, right? He brought witnesses. And the state legislatures didn't change it. They said, no, we're going to let this certification go through, even though they had the absolute right to do so. Now you're saying that we're wrong. You're saying the state legislature were wrong in not changing and not doing something. But they did. They allowed the certification to go through. That's why Texas doesn't have standing. The legislature made that decision.
That might only confirm the fact that the legislature doesn't mind the fact that the executive broke the law, and that might just add to Texas's prejudice, and that might add to Texas's claim that you have a state now that is violating the Constitution and legislators that are ratifying that violation of the Constitution because they want that outcome, and it's prejudicing Texas. And
you're making two arguments though here now.
Because I'm making one argument that they violated the Electors Clause of the Constitution because the executives modified the laws that the legislative passed. That's my one.
Now, all right. So let's say that's true. And did the legislature have an opportunity?
I don't care about that.
To change the outcome.
I don't care about that.
Now, at the end of the day, who chose to certify the electors that went forward?
I don't care.
It was the electors. It was the legislature. Now you can say you don't care, but that is the issue. The same legislature that you're saying has the authority were the ones who said this is okay. We're certifying.
You're saying that they didn't. That's it. You didn't say that though. You said they just didn't do anything, and that by doing that they acquiesced essentially.
No. Well,
they passed the law. Not stop it from going forward.
The legislature passed laws.
What Nate is effectively saying is that the legislature could have remedied the violation of their laws as drafted by not certifying. Too late, damage done. There's a protocol. It's in the Constitution. Legislature creates the laws for the elections of the president. The executive have violated those laws. Texas is saying, you guys are not respecting the Constitution to which we are all a party. I don't care that your corrupt government then certified or ratified the unconstitutional election. That's why I want the SCOTUS to come in and remedy this wrong. That's the argument. Now, maybe they lose on the merits, but to have the SCOTUS, and I don't care that I'm looking at the chat. I don't care that 7 SCOTUS members said it. That doesn't make it, when unanimity on the bench is not necessarily a sign of correctness. It might actually just be a sign of partisan issues. The fact
more like, for instance, Morrison was 8-1, and Scalia was right. He was the one that was right. So to that, I'm not arguing that. What I'm arguing,
but the idea is, even if this loses on the merits and there's a fleshed out 1 hour where we've only been going for 40 minutes, the Supreme Court, it undisputably, if it's so obvious, motivate the bloody judgment beyond 2 sentences. Sorry. If it's so obvious, explain why it's so obvious. Something is not obvious because you ignore it. And I think it is in fact so complicated that, and I think the arguments are legitimate. And the whole issue is not what would have been the outcome had the Supreme Court heard it. The whole issue is they abdicated their responsibility by refusing to hear it in the first place off a technicality that is arguably applicable to the circumstances. Boom, 104. That's going to be the clip for this video. But it's right. I don't even care, Nate. You might be right, but it needed justification in order to satisfy people's passion.
I feel heard. I guess that's it. And
I think unfortunately people just have to just understand the law is what it is. Texas is saying it was injured because the legislature had the right to do whatever they wanted, right? To pick their electors, and they're saying that didn't happen. But we all know it actually did happen, right? Because the legislature is the one that passed these laws. The legislatures are the ones who let this thing happen. And the legislatures at the end of the day were the ones who allowed certification to go through, even though they could have stopped it. And they passed the laws when the Georgia state legislature, for instance, in Georgia, the legislature doesn't certify the election. It's the Secretary of State. But who gave him that authority? It's the legislature who passed the law, who got together and said, we're going to give it to this guy. And whoever this guy certifies, that's who we're going to go with. And so I don't think now to say that the legislature's will has been violated. I think I just don't see it here because, again, it all comes down to the legislature is the one, when Rudy Giuliani went to Pennsylvania and was asking them to put in another slate of electors, then you're essentially saying that was all for naught. He didn't need to do that.
Well, I mean, he could have done it. First of all, I think he did need to do it, not for political reasons, but also for public opinion reasons and for getting the information out there, because media sure as heck wasn't covering it, and they barely covered his conferences. But as far as I'm concerned, and my argument would be, and I think it's something that the Supreme Court ought to have addressed, even if the legislature ratified the unconstitutional application or the unconstitutional modifications of their laws, that still goes to whether or not the Electors Clause of the Constitution was followed. The legislature cannot ratify their unconstitutional deeds. And if the court wants to say they can, let the court say that all the legislature has to do to hide their wrongdoing and their unconstitutional modifications of the laws they passed by the executive is ratify it. Let them do that. Let's see what happens.
But now who gets to say that because you guys keep saying that as if it's a fact, right? And I've been taking it as a fact, but you guys keep saying, how is it that they can violate their own laws? I don't think it's not a reasonable interpretation when the legislature.
That's not exactly what I'm saying.
Hold on. Well, I'm just. I'm saying. So explain. What are you saying? So
I guess what I'm saying is that there are the Electors Clause, as I understand it, written in the Constitution.
Okay.
And the state legislature, following the Electors Clause, wrote out one thing of how they were going to go about this process.
Okay, good.
They did not, in fact, do that process. The people that they delegated to, the executive branch, however you want to put it, said, oh, never mind that. We're going to do something new here. Now, that new thing came in from the side. Okay. And it was not, it's moved away from the Constitution because it's something that was not in the process that was accepted by the Constitution. Now, I'm just saying how I interpret it.
there's a problem with what you're saying.
Okay.
Is that you're mixing both state law and federal law together. In
well,
the
I'm
sense
saying
of
that the federal law established something, and then the state law is carrying it out, or the
Okay.
state's carrying out
Correct.
their job, because their job is to help elect the president, which is
all right.
federal.
So now let's go back to the first thing that when you mentioned it. You said the state legislature passes laws,
Sure.
and you said that obviously something went wrong with the executive. Who determines if the executive at the state level has
Mhm.
violated state law?
Supreme Court can, period.
Not the federal Supreme Court.
Well,
No.
in general,
It's-
the court would be who I would imagine
Mhm.
does it, but this is
the
where
state
it gets
Supreme
into these exceptions. That we all agree that the state court could be wrong. That's why there is a Supreme Court.
No,
that's
wrong.
not why there's Supreme Court.
Wrong.
But the state court can be wrong. They
All right.
absolutely can be wrong on the
no,
law.
No,
Or some law.
no. When we're talking about now, this is where now again, this is where we get into the weeds.
Mhm.
The federal courts are courts of what they call limited jurisdiction. Limited
Sure.
jurisdiction means that they can only hear certain cases involving federal law, like you guys are saying, the Electives Clause, and other things. Then state courts are courts of what they call general jurisdiction. They can hear both state and federal law.
Okay.
So what happens is that because they are separate sovereigns, the state Supreme Court is the final arbiter of state law. So when the state Supreme Court says this is what state
That's
law means,
unconstitutional.
yes. When the state law says this is what state law means, or this is what the state constitution means, the Supreme Court cannot overturn that state law's
Unless it
interpretation of
violates
state law,
the U.S. Constitution.
unless the state law violates the U.S. Constitution.
Well,
but now hold on. Just let me finish.
And
Just let me finish this point. How did the executive violating state law violate the U.S. Constitution?
because it was created based on a constitutional precept. If that's the right word. You see, this is where I hate it, because I don't have the knowledge or the vocabulary to say it. I'm just looking in terms of rule books. And my biggest issue is that people are spinning themselves in circles here who are really smart. You, Viva, and everything else. Why the hell couldn't they just say, okay, let's listen. You're wrong. This is why. Boom, done. There's a decision. I think the biggest argument and what really started this whole discussion wasn't even what the outcome would be. It was whether the Supreme Court should actually say, okay, I think as Clarence Thomas put it, he probably would say no anyway. Or he and Alito, they said that they probably wouldn't give the decision anyway, but they'd hear it. Mm-hmm. I think that's the big issue that so many people have, is that why didn't they let it be heard? Let them argue out how that's BS or it's not the Constitution or it's not.
Let the Supreme Court say that an unconstitutional state law, when it comes to the election, does not violate the Electors Clause in the Constitution. Let the Supreme Court say that, because that is effectively what Nate is saying, and I disagree. I mean, hold on.
I don't want you to straw man me. You are not saying the state law is unconstitutional.
I'm saying Nate, that's the premise. That's the premise of what we're saying.
But again, the state law, you're saying the state law is unconstitutional because it violates the Election Clause, and you're trying to make this attenuation that because it can't be the state law is unconstitutional because the state law is passed by the state legislature.
But the whole point is that it wasn't.
So the state law can't be unconstitutional.
That's the whole point. What they did in terms of the vote was not passed by the legislature.
But let's be clear with our words. The state law itself is not unconstitutional, right?
No,
that's not
the law as far as I know.
Yeah, because that's what you guys keep saying. The state law is unconstitutional. So that's what you're saying is the enforcement of the state law was unconstitutional. Just to be clear.
What Texas was saying is that the election process in the state of Pennsylvania, just one, in furtherance of its constitutional contractual obligations under the Electors Clause, was not followed, and the measures they implemented were unconstitutional in that they followed laws that were unlawfully amended from that which the legislature passed under the authority of the Electors Clause of the Constitution.
So this, but again, the state laws are not unconstitutional. No, so because everybody's in the chat is probably going to be like, the state laws are unconstitutional, but I don't want to make it
the manner in which the vote was carried out was unconstitutional in that it violated the law as passed by the legislature under the authority of the Electors Clause of the Constitution.
So we're saying the state laws are constitutional, but we're saying the enforcement of those state laws, right? The way it was enforced, right? The way it was executed was unconstitutional. Exactly.
I am saying and I'm saying, more simply put, the manner in which the state of Pennsylvania carried out its rights and obligations under the Electors Clause of the Constitution was unlawful.
All right.
Unlawful at a state level with consequences at a constitutional level. Inasmuch as certain members of the society cannot vote, that it had an impact on the authority and the provisions and the rights and obligations under the Electors Clause of the Constitution. Now, I understand what you're saying. It's a state issue. It was certified by the legislature, so they ratified their own.
I wasn't going to say that. I'm saying you're saying the state law is constitutional, and you're saying the enforcement of the state law isn't. The state law itself is constitutional, right? I just want to make sure because if the state law is constitutional, then we're talking about the enforcement and interpretation of state law, which you're saying was unconstitutional because Texas says so.
I'm saying Texas is questioning it.
Yes, Texas is saying,
and
hey,
Texas doesn't have the authority to do
mommy and daddy type of situation. I mean, that we're all they're all children. Texas is a child, and Pennsylvania is a child, and Texas is saying, hey, they didn't follow the rules. We're following the rules. They didn't follow the rules. Mom, dad, listen. That really is kind of how I see it.
It's more primordial than that. They're saying they did not follow the rules as provided for under the Electors Clause. The only court that can hear that is SCOTUS.
All right, but that's where I think we have a fundamental disagreement. They did follow the rules under the Electors Clause. Why? Because the state legislature passed the law. That law, we all agree, is constitutional. Whatever law they passed, right? They passed the law. Now you're saying is that the way the law was executed was wrong, right? You're saying
no. I'm saying they unlawfully modified the executive unconstitutionally, unlawfully modified the law that the legislature passed under the Electors Clause of the Constitution. Now you're going to say, but it was a constitutional law. It just wasn't enforced properly. 6 of one, half a dozen the other. And if
that's what you're saying, though. That's what you're saying. You're saying the law was constitutional because everybody will be saying the law is unconstitutional. And I'm saying no, the law wasn't unconstitutional. We're actually saying the law was constitutional. You're saying it's because the executive did something other than the law. You're saying he violated the law.
I'm saying the law that what they followed was unconstitutional. The law that they were supposed to follow might have been constitutional. I don't know. I'm not going to say it's unconstitutional. Right. So what they did was unconstitutional in that it modified the substance of the law that was constitutionally passed.
Okay.
Now, if SCOTUS wants to say, and I know because the argument is going to be this is enforcement of state law.
Yes.
Okay. It's enforcement of state law that exists under the authority of the Constitution, and therefore it's not a state law like liquor license or building permits or whatever. It is a state law that is created under the Electors Clause of the Constitution. And if SCOTUS wants to come and say, and from what I understand, incidentally, it's the exact opposite of what they said in Bush v. Gore, that the way the state implements its Electors Clause it does not have an impact on the other states. If they want to say that, I think they're going to have to defy their own precedent. And if they want to say that, let them say it. But they didn't say that.
Just please say it.
Get out. Well, the thing is that I don't think they should have said it because I think the standing issue is still clear. And I'll just explain, just quickly say exactly why I think the standing issue is still what it is. The state legislature passed a law, which you all agree is constitutional. That law was executed in a certain way that Texas says, okay.
That was unconstitutional.
Hold on. Let me finish. It was executed, right? You guys saying it's unconstitutional, but Texas is saying it was done in an unconstitutional manner. What's the unconstitutional matter? They're saying it violated state law, right? So we have this circle. Texas is saying
no, stop.
All right, go ahead.
They're saying it violated the Electors Clause.
But how can it violate the Electors Clause when you're saying because if how could the state law can't violate the Electors Clause? We've already said it doesn't.
If the state law can't violate the Electors Clause, you have a right without You have a right without a remedy in the Constitution. And we just went over that. The state law is constitutional. It does not. The state law itself doesn't violate. The legislator passing the law does not violate the Electors Clause. Okay, so
is there any disagreement with that?
Nate, you're making a distinction. What is it called? It's a distinction without a difference.
No. The legislature has the manner in which to pass the law to make electors. So if the legislature passes a law and says we're going to have a dog race, and that's the way we're going to pick electors, Texas then does not have standing to challenge that, right?
Except if they say afterwards, the dog that won the race,
we race cats instead.
So let's say that this happened. Let's say
we're making a silly analogy. If the legislature said it's a dog race, and then the executive came in and said, "No, I decide,"
Let's rate yes. And let's say the executive says, you know what? This dog race thing is stupid. I'm going to just pick it. It's going to be this guy. And then the legislature after that comes back and says, well, you know what? We're going to certify. Yeah, okay. Let it be that guy. Let it be that guy, right?
That I have is you're not saying that they said, hey, we certify you. You're saying they just said nothing. And they let it happen. And by letting it happen, that was a tacit agreement. That's what I heard earlier because they didn't.
That's wrong. The legislature passed a law on certification, right? The legislature. So in this situation, there are a couple of different ways. Some state legislatures actually go and take a vote and say, this is, we're going to certify the election and these electors. In that situation, you definitely don't have standing because the legislature has picked the electors in a manner in which they choose. They actually pick them, right? The popular vote, then they actually pick the electors. So in that way, Texas does not have standing. So any state that does that, it's over. The second way we're talking about is where the state, there's a dog race, right? There's whatever dog race. And the governor says, well, I'm doing it my own way. And then the governor picks another elector. And then the legislature doesn't act. But the legislature has passed a law like it did in Georgia saying, well, you know what? We're not going to make that choice. We're going to let this guy make the choice. And that guy, he says, well, you know what? I'm going to go with the governor. I'm saying Texas still doesn't have standing because the state legislature, by choosing who can make that choice, they're not saying we're going to make the choice. They're saying we're going to let the state secretary of state make the choice. We're going to pass a law that's constitutional and have that guy make the choice. And if that guy chooses the instead of the winner of the dog race, but whoever the governor picks, then that's also constitutional. And then Texas itself does not have the right to then go in and say, well, state legislature, by letting this guy choose it, by passing that law, letting this guy choose it, that's wrong. That's what
I want to get into the, I'm going to have to look at the details because that's the stuff that I don't see or completely understand. I would have to actually read the law and see, does the law say that, okay, here is the process that this election is supposed to happen. Hey, go do this. And by the way, at the end of the process, Secretary of State, you're in charge, you certify, we're good to go. And if that sounds to me what you're saying is that in the law, they're saying that here's the procedure, what we want to happen. And at the end of it, the deciding person, according to us, is going to be Secretary of State or whomever. Mm-hmm. It's not there. So you're saying they have delegated their responsibility to said person. And so at the end of it, if said person that they delegated came forth and said, okay, I certify, you're saying, well, then they followed that part of the law to certify it at least. And if the state legislature doesn't do anything about it and they followed the part of the law that said that they could do it, then they in effect have certified it.
I'm saying the state legislature has chosen the manner in which they certify elections, right? The manner in which electors will be chosen. As Article 2, Section 1, Clause 2 says, each state shall appoint in a manner as the state legislature thereof may direct a number of electors. They chose to appoint this person to choose the electors. And sometimes they do it, they choose the popular vote. If they choose this one person and say, you certify the winner after a popular vote or whatever, and that person certifies, then the state has chosen the manner, right? They've chosen this guy.
The problem is that if they wrote a whole procedure, Nate, I feel like there might be some cherry picking going on because it's like they didn't just say, Bill Smith, you're going to pick the electors. They said, here is an entire process of how Bill Smith is going to agree that the electors are picked, according to what you're saying. So now you just say, Bill Smith, here, you're going to conduct these 5 steps. And Bill says, you know what? I don't feel like doing these 5 steps. So I'm just going to say, here's 5 names, boom, boom, boom. Or here's my 5 votes. I'm going to stick them forward. Your argument then is that, well, the legislature said that Bill Smith can do it. So it doesn't really matter if Bill Smith didn't follow any of the instructions along the way. Bill's the man. Am I correct?
Because at any point in time, the legislature didn't go in because what's going on here, just to be clear, the legislature passed these laws and you're saying, and they say Bill Smith is not following any procedures. Then the courts, right? Because people then took them to court. They went to court in Georgia and they went into the court. They said, well, hey, guess what? Bill Smith is not following these procedures. Bill Smith is wrong, right? Bill Smith is wrong. He's messed up. And the Georgia courts who interpret the law says, no, Bill Smith is actually right. This is what the legislature intended. We get to interpret the law right? That is our constitutional right. And because, Republican form of government. So we say Bill Smith was right. And then at the end of the day, Bill Smith now can certify the election. Why? Because we have the right to interpret Georgia law. That's what I'm saying.
Viva, sorry, I stepped
No,
in.
no, the analogies are getting confused, Nate, and it seems like it's what we call, I'm looking at some of the comments, but ex post facto justification in a sense. It says the Constitution says the legislature has to set up rules. That's what the Constitution says.
No, it says a manner, but rules, I'll give you rules.
Now, the defense is not going to be the legislature set up rules. The executive unconstitutionally violated those rules, and
no, not unconstitutionally. I don't agree with that.
The legislature then says, "Well, we're going to certify the electors anyhow," which therefore means that we've picked the electors in accordance with the rules. That's I mean, it's circular reasoning. But even if that's what the Supreme Court is going to say, they're basically going to be tantamount to saying that the Electors Clause means nothing. It doesn't create any obligations on the legislature to follow the rules that they've legislatively passed. And that's the end of it. And all they have to do to sanction their own unconstitutional conduct is certify the electors. Okay, if that's what the SCOTUS wants to say it, and then see what people react to that.
But where are you getting all this? Because in the Electors Clause, this is each state shall appoint in a manner as the legislature thereof may direct. I direct Bill Smith. Hold on. Let me finish. I direct Bill Smith to give me electors. That's it. I don't see. It seems like you're adding all of this. You've added like 3 paragraphs to that. It just says
in the manner in which the legislator passes, and they didn't do it. Because the executive unilaterally and unlawfully modified.
That's a conclusion. That's a conclusion. That's a conclusion. That's a conclusion. That's a conclusion that
alleged in the lawsuit, and that's
a conclusion. That's a conclusion that has no standing and no basis in standing. And the reason why is because the people who are constitutionally able to make that decision, if the laws were broken in that state, or the judiciary, right? Is the courts of Georgia. Georgia courts determine if Georgia law was broken. And now you say Texas is saying Georgia law was broken. Even though the courts in Georgia says no, that didn't happen. The courts in Georgia are saying Texas is wrong.
Now you're confusing a number of things. What Texas said is that the Constitution says that the legislator shall set the rules for the election, to simplify it. They are alleging that the legislature set rules that were unconstitutionally modified, and it's that, therefore, that the protocol that was followed was not that which the legislator set forth as required by the Constitution. As a result of that, they have suffered prejudice. Now, that's the argument. Now, what you're saying is basically you're saying that's the argument. So the argument is not that they violated state laws that relate to something else. Their argument is that they unlawfully modified the constitutional requirement that the legislator set the rules for the presidential election. As a result of so doing, they are being prejudiced because they followed the rules, and through the chicanery of having modified that which the legislator provided, their vote is being diluted. That's the argument.
Okay. And that's why I believe this argument fails. It's because the legislator passed laws. That laws is telling you the manner. So we're not saying the laws itself are unconstitutional. The legislature passed laws. Those laws were executed, right? Those laws were interpreted. They were executed by the thing. Even if you're saying they're executed poorly or they were executed wrong, they were executed in a way. And then the courts, then it went to court, right? People were saying, well, you people complained that the Georgia officials executed the law in the wrong way. They went to a Georgia court. And a Georgia court, who is the final arbiter of Georgia law, looked at it and said, well, guess what? It didn't violate Georgia law. These were correct, and this is why it needs to go forward. So now when you go back to the Electors Clause says the legislature can choose a manner. Well, what manner did they choose? They chose to pass a law. They chose to have the executive execute that law, and that by doing so, they chose to have the judiciary interpret that law. And by doing so, now Texas can't go, because eventually what you're saying is that now Texas can tell Georgia courts that they didn't interpret their laws correctly. That's the reason Texas doesn't have standing. Texas doesn't have standing for one reason. And the reason is because the Georgia legislature passed the laws, and then at the end of it, they decide how these votes were going to be cast, and they decided who's going to certify that vote. All of that did happen. Texas has no role in that. That's simply what it is.
That's the conclusion. And I think that's exactly where we all disagree. The only issue is the Supreme Court didn't explain any of what they thought as to why. Just no cognizable injury, where they alleged a cognizable injury. They alleged a violation of the United States Constitution by virtue of state law violating the Electives Clause of the Constitution. State law or unconstitutional modification to state law, which violated the Electives Clause of the Constitution, to which all the states are a party. The only court that can hear it is not whether or not Pennsylvania's courts are going to determine whether or not they violated the U.S. Constitution. It's going to be the Supreme Court.
And Pennsylvania courts can determine if they that.
But the original jurisdiction clause is that they can go straight to the Supreme Court, and it's provided. So that's it. That's it. Look, I don't think we're never going to convince each other because you agree that you think the ultimate issue also is I think everyone agreed that it was an uphill battle. Standing would be. I mean, for everyone who's calling me a partisan hack, I said as much in my analysis. Standing was always going to be the issue. The major issue is that in an hour and a half of an hour of discussion, we're fleshing out the rationale that the Supreme Court didn't even take an hour to do. That's it's not. Well, I don't care what anybody thinks. It's not a cut and dry issue. It's not a slam dunk because 7 judges said so. And it required reasoning so that we could see what the reason was. If they were to adopt your reasoning, that would be precedent for the rest of elections in the U.S.
Well, just to be clear, the reason why it's like for instance, I listen to I listen to everyone from George Conway to all these constitutional scholars everywhere, and this is more or less, even if you go to SCOTUS's blog, this is what they essentially were saying, and is that the Electives Clause understanding is that the procedures that are put forth in the Electives Clause, right, to say the legislature has this ability to do that. Sometimes they did it by themselves, and now they choose to allow the executive and all these other people to do it. And in doing that, I think we all have to understand that Texas cannot go in and say it just would violate every single principle of federalism for that Texas can go into another state and say, well, you're violating your own law. Because again, they're saying the violation of federal law, from what I'm understanding that you guys are saying, is all hinged on one thing, is that they're saying that Georgia, that officials in Georgia, both the executive and the courts, violated Georgia law, right? If you don't have that, then the cause of action goes out the window.
Yes,
I'm saying that analysis that Georgia officials violated Georgia law, Texas has no standing.
No, you're just repeating the conclusion. I'm just going to go to Kathleen. Bring up Kathleen.
Okay, exactly. That is the conclusion. That's what I'm saying. I'm saying they don't have.
Viva mentioned the executive branch in Pennsylvania. The governor amended the Pennsylvania election law illegally. Governor allowed everyone to vote by absentee ballot. That was not part of the law. There's no doubt that the underlying issue is that there was an illegal, unlawful, unconstitutional modification of state law that has an impact and an influence on the Electives Clause and therefore affects Texas. That's the argument. Now, I'd like to hear Texas the SCOTUS. I'd like to hear SCOTUS in detail why that argument fails above and beyond.
And I'll tell you. And it's simple. It's simple. And this is what most scholars would say, because Texas can't determine if Pennsylvania violated Pennsylvania's law.
No, that's what they went to SCOTUS for.
They do not have the authority to do that. They don't.
Texas is not trying to do it. That's what you
said like 3 times. You said Texas saying
that's what SCOTUS would do.
No, that's what they're alleging.
But that's
all right. Let me be clear.
Nobody thinks that SCOTUS blog is more a credible source than it is. It's not official SCOTUS, correct?
Hey guys, no. What I'm saying is just simple. You guys, you can't have it both ways, and I think that's what you guys are trying to do. You guys are trying to have it both ways.
We got somebody in here.
Oh, I think the census. I think he's right on this one. The census thing was cowardice. That they shouldn't have punted on that. But I think in this way, it seems like you guys want to have it 2 ways. And I think that the one way is saying, well, the state legislature,
we want everything.
The state legislature passed the law, and we don't like the way that law was enforced, within that state. So now we're going to say that enforcement, the way it was enforced, the way it was executed, violates the Electives Clause of the Constitution. But I still don't think you get there, because I don't think I've heard anything credible to say I've heard it violates the Constitution. How? I don't know. I'm just trying to understand how the state passing a law then that law bring in a result, even if they violate the law.
Because they passed the law under the authority granted to them by the Elective Clause of the Constitution. This is not just
so they passed the law under that authority. Okay,
That's
go.
right. And so any violation of that law, even if it's at the state level, can potentially have an impact at the constitutional level, and that potentially impacts Texas. And if the SCOTUS doesn't think that that's the case, and the SCOTUS thinks states can do whatever they want in terms of violating their own laws as relates to carrying out their obligations under the Elective Clause, let them say as much.
All right. So now, just to be clear, they passed the law. That law was violated, and because that violation, you're saying it violates the federal Constitution, which I'm saying I do understand. I understand that's a sensible argument and it's a reasonable argument. I'm not saying it's a bad argument at all. I'm saying I understand it. I'm saying it's reasonable. But I'm saying based on our constitutional principles here in the United States, one states the people who determine, number one, what state law means are those states. So it's the state Supreme Court and the state legislature. The state legislature has passed the law. It went to court. People challenged it, right? Because what you're saying has been challenged. A lot of the stuff in the Texas lawsuit was challenged in state court. For instance, in Pennsylvania, in Georgia, in Michigan, and in Arizona. It was challenged in state court. It went to the state courts, and the state courts looked at the evidence and said, well, guess what? We don't believe that these things violated the law. So now we have the state law, state constitution, and the state legislature. Everybody's saying, okay, this was good. And they sit there electors. Hold on. Let me finish.
Yeah,
they sit there electors. All right, you can disagree, but let me finish. Hold on. Just let me finish, Viva. So the state. So just in case, I got the state legislature, the state executive, the state judiciary. Everybody's saying these electors are good based on our law. Here you go, Stokes. Here you go, federal government. And then Texas saying, well, no, there was some violation, and they're saying no. The state legislature passed the law. Everybody agrees this is good law. These are good electors. I disagree
with what you're saying. As a matter of fact, nobody said that they did not violate state law. The SCOTUS's decision was not based on the state.
I'm not saying SCOTUS's decision. I'm saying the state legislature in Georgia says they're good, right?
I don't know. I don't think so, and it doesn't matter.
The state legislature. All those people didn't say that those votes were good. They certified the election.
That doesn't mean that they didn't have unlawful modifications to.
No, I'm not saying unlawful modifications. Were the electors that Georgia sent to the Electoral College? Did the Georgia courts agree that those?
Now I'm going to tell you that this is what you are. You have a moving target of what you're asking for. You said that you said a second ago the states said all the laws were good. They did.
The states are saying our laws are good, right?
They did.
Because hold on, but we all right. So now we're moving it because before we said the state laws were constitutional, but they enforced.
No, that's not
the state laws are good. No, the state laws are good.
You just said that the states said that their laws were good. Nobody said that.
Saying in the response to the Supreme Court, they're saying our laws were good. Our laws were followed. We're all good.
Okay, guys, I'm out for a second because I know that Nate has kids to pick up.
No, I got
to go in 10 minutes.
Do we do it? No, I think we've gone in circles anyhow. But
what I would love is please everybody in the comments, let's tear it up. What do you think? Decide this. We are at a complete standstill.
Let me just screen record here. Boom. How are you going to how are you going to go by names?
It's going to be Viva V Nate. Okay.
This is only going to be an indication of the political orientation of your audience, Eric.
The majority came from you, so it's going to be the same thing.
It's funny because if I was on what's the Legal's channel, everybody would be like, "Yeah, Nate is right. Nate is right." You're on here. Nate is wrong. Nate is wrong. So
the bottom line is
that's what I'm happy. I'm happy about having the discussion.
It doesn't matter who was right or wrong. It just matters. This was not a two-line decision. Yeah. And the Supreme Court, by doing what they did, punted it, and it's cowardice, and it's beyond cowardice. It's going to undermine not just the SCOTUS, not just the election process. It's going to undermine the SCOTUS for years to come. And I don't care that I know people on the left, who people say they're on the left, say it was so obvious. It was so obvious. That's why they got a two-liner. I don't care, and that's bullcrap. That is arguing from a conclusion, not towards it. It's so obvious. I don't have to explain myself. Crap. You're the SCOTUS. You have to explain yourself.
Well, before I leave, I'm going to say this was one of the best decisions that the Supreme Court could ever make. It was based on standing and based on the constitutional principle. Again, based on every constitutional principle in that we have had here in the United States. States are sovereign, the federal governments are sovereign, and the states passed a law. When the states pass a law, then that allows them to execute that law. So the federal government does not have the authority. If anybody tells you that the federal government has the authority to interpret state law, no, it is the state Supreme Court has the final arbiter of state law. That's why 7-0 Supreme Court decision. That's why most constitutional scholars. That's why I was able to call this the day I read the decision. That's why I said it was going to be decided on standing. I was extremely confident about it, and I told everybody. So this is so. Hey, we can say whatever, but I believe that if you, in 100 years from now, when people look at this decision, this is going to be about state sovereignty, because nobody wants somebody from California going into Texas and telling Texas that their abortion laws violate the Constitution, because you know what Texas is going to say? Well, California doesn't have standing to do so. Bingo.
Yeah, and abortion laws do not have federal. Do not have.
Yes, they do.
They do not have national impact. They are state citizen impact issues, and not one. The president.
Hold on. I can definitely tell you, yes, they do. They definitely do. They have interstate commerce issues. If you can't have an abortion in Texas, they go over to the next state to have abortion. So you have interstate commerce. You can definitely make the argument for that. You make an argument.
You can make bad arguments too. The abortion laws are not the same.
And that's what this argument was that Texas made. Bad argument.
Abortion laws do not have the same national impact that election laws do. And period. And if you want, I don't know. Bad analogies are bad.
I agree.
Your entire justification was already a 3-page judgment. Nobody is going to look back at this piece of paper in a year's time and think it's worth anything more than tissue paper, because it was not reasoned, it was not motivated, it didn't refer to precedent, it didn't refer to facts, and it didn't do anything other than say we're sticking our finger in the air.
It was an obvious.
So there we go. Hold on. Those are the final statements on both. Nate says it's going to be seen as a monumental, brilliant decision in 100 years. And Beaver is saying that it's going to be toilet paper in 100 years. And everybody is going to subscribe to the channel and put in the comments what they think and tell all their friends. I think this is a blast. And you guys are just so much fun to hang out with. Seriously.
Yeah, this was fun. And Viva knows I love him.
I'm still learning. At some point, it's not a question of stubbornness. We're going to have our separate opinions. I think Nate might be right on the merits, but I would have liked to have seen how the Supreme Court got there. It's a lot easier to get there by not explaining your thought process than it is by having to explain it. And that was the cowardice of the SCOTUS.
Perfect conclusion. Everybody, thank you so much.
I'm surprised.
Nate, I was like,